We are on the record, Your Honor.
All right, thank you. And Mr. Clerk, you're there and ready to go?
Yes, Your Honor, I'm here and ready.
All right, thank you. All right, so good morning, everyone. I have two matters today. I'll start with Zahavi versus Nacito. Attorney DiBartolomeo, this is your motion to open the judgment, so you can proceed whenever you're ready.
Yes, good morning, Your Honor. It's our motion to open. Prior to the hearing and damages, we had filed an answer which would cure the default for failure to plead. So based on section 17-32, it was our belief that hearing and damages should have been canceled, and then the matter proceed accordingly. So based on that, Your Honor, we're respectfully asking that the judgment based on the hearing of damages be open.
Okay. Give me 1 second. All right, so you filed an answer on September 11th?
Correct.
And the hearing and damages was on September 16th?
Correct.
Yes, Your
And
Honor.
then the notice of that hearing going forward was posted towards the end of October, I believe, Your Honor.
Well, when did you file an appearance?
The appearance was filed around December of 2024, Your Honor. And the main reason, because I'm assuming where you're going, is I handle a lot of the real estate stuff for Mr. Nacito. He was supposed to get different counsel, and as time went on, he asked me to file an answer. And so that's without getting into too much of the attorney-client, that's what happened.
All right, but did you had noticed that there was a hearing and damages on September 16th?
Yes.
And why didn't you come to the hearing and damages?
Because it was my assumption, Your Honor, and I may be incorrect, that the filing of that would nullify that. And again, I asked my client for months to get counsel that's more for that, and based on our conversations, that's what happened.
Mm.
Looks like we lost the judge.
Sorry about that, having a little trouble here. All right, Attorney De Silva.
Yeah, for the record, Your Honor, Joseph De Silva for the plaintiffs. I'm somewhat mind-boggled today, and baffled, because 17-32, which counsel just relied on, 17-32 says, and I'll read it for the record, Your Honor, if I may. Subsection B, if a party who has been defaulted under this section files an answer before judgment after default has been rendered by the judicial authority, the default shall be automatically set aside. Counsel stops reading there. Most of the section follows that, however, because it says set aside by operation of law unless a claim for a hearing and damages or a motion for judgment has been filed. That was filed in March. If a claim for a hearing and damages or a motion for judgment has been filed, the default may be set aside only by the judicial authority. A claim for hearing and damages or motion for judgment shall be filed before the expiration of 15 days. The motion for hearing and judgment was filed more than 15 days after the default was granted. It was filed in March. Counsel did nothing. In fact, counsel filed a request to revise in January. We revised it 1 day later. No answer was filed. When the motion for default was filed in February, requests for admissions were filed concomitantly therewith. No response to admissions has ever been filed. All of those admissions are deemed to be granted. The motion for default was granted in February. The hearing and damages request was filed in March. Nothing was done. A hearing and damages date was set for July. I was going to be away when that was scheduled, so I asked counsel for consent, and he granted it immediately to file a motion to continue that hearing and damages. It was extended to September 16th from July, 2 additional months. Nothing was done at all. No, an answer was filed 5 days or 4 days before the hearing and damages. That did nothing. That had no effect of any kind. More importantly, a reading of that answer shows that they admitted one fact, the identity of the defendant, and left the plaintiff to its proof on every other allegation, which in light of the request for admissions, they're done. This case should be decided. This case could have been decided on the merits that at the hearing and damages, because the request for admissions admit all the salient facts. They're binding admissions on the defendant. The defendant cannot deny a claim that's made by the plaintiff at this stage because they left the plaintiff to its proof. And when you leave the plaintiff to your proof, you're no longer allowed to deny those claims. This is mind-boggling that we're here. An appearance was filed a year ago. The defendant did nothing. I understand counsel thought other counsel was coming in, but they didn't. I don't know what that arrangement was. I don't know why it was, but the deeds of case that we cite in our objection clearly states that a court should not open a default judgment where the defendant admits they received actual notice and simply chose to ignore the court's authority. Nothing could be more stark here. The defendant's been ignoring the court's authority, ignoring the rules of practice for a year. The defendant had notice of the hearing and damages on the 16th of September and didn't deign to show up. The practice book is clear. The filing of that answer had no effect of any kind to set aside the default. They needed to request the authority of the court. They might have been able to do that had they bothered to show up on September 16th. This motion needs to be denied. My client needs to be able to move forward on his judgment.
Well, let me ask you this. He's asking for it to be set aside now, right? I mean, he's asking he's asking to open the judgment. Isn't that my call?
Well, it's absolutely within Your Honor's discretion. It would be our suggestion Your Honor should not exercise that discretion. This was not, I missed a day. This was not, I filed a day late. This was not a situation of I thought an answer was filed and it wasn't. This is ignoring the practice book. This is not reading this section we're relying on even after getting an objection. We filed our objection on October 17th. Counsel's had that objection for almost 2 months. Counsel walks into this hearing and says the filing of that answer immediately set aside the default. Counsel didn't even bother to read the objection. The defendant didn't show up at the hearing. Counsel didn't show up at the hearing. Had they read that section, they would have known to show up. They would have known to ask Your Honor to set it aside that day. This is just plainly just ignoring the rules of practice. More importantly, even if their answer were credited that day, even if they'd showed up at the hearing, we could have had a hearing at which time they wouldn't have been able to defend because the admissions are established. The admission establishes all the salient facts. There's been no request to set aside the admissions. There's been no request to allow answers. There's been no answers. In fact, other than filing an answer, they've done nothing. A request to revise, their request to revise was answered within 1 day. They did nothing for 10 months.
All right. Attorney DiBartolomeo, I guess my question to you would be, it's the hearing and damages was on September 16th. I didn't issue an order until over 3 weeks after that date. So
Correct.
Again, if there was a time to sort of address the situation, I mean, you indicated you had notice of a hearing and damages, and if there was a time to address the situation, court's purview, it would be between, the hearing and damages was held. A week went by, there was still no order, no judgment from the court. 2 weeks went by. So you had approximately 3 more weeks in between the hearing and damages before a judgment was entered.
Correct. Understood. And again, you know, the way Attorney De Silva is stating is that this is some calculated, it sounds like that I did this calculated thing. And
well, I guess, you know, from my perspective, it's like a, you know, calculated, you know, from my, what is it, it doesn't matter to me, you know, in terms of, I don't think it was necessarily calculated, but
and it wasn't.
I guess, you know, I'm just looking at it from just, you know, as a matter of, you know, time, you had significant amount of time to address this.
Understood. And again, I can't go into all the conversations I had with my client, except to say, get somebody else for this, because this is something that I don't, and I filed my appearance in that as favors to him. Okay. But that's my decision. I have to live with it one way or the other. Okay. But basically, like I said, when we filed that and I didn't see that anything had happened, I went under the wrong assumption that everything had gone off and we will go forward and tell Mr. Nacito he's got to do whatever he's got to do as this case goes on. Then we saw that that the decision came down a few weeks later, and then I filed what I filed. That's it. Nothing else other than that. That's what happened, Your Honor.
Okay. Attorney De Silva, do you want anything else?
Briefly, I'm not going to accuse a fellow member of the bar of doing something targeted or intentional. But that said, I don't know that Mr. Nacito wasn't doing that, because according to Attorney DeBartolomeo, he had 10 months to hire new counsel from the time the appearance was filed. More importantly, this wasn't filing an appearance to avoid a default for failing to appear. Attorney DeBartolomeo filed a request to revise. He filed a responsive pleading. Then nothing happened for 9 months. A simple call to the clerk after filing the answer would have revealed that hearing was going forward. Showing up would have revealed that hearing was going forward. Checking the court's docket that day would have shown the hearing was going forward, because it wouldn't have been marked off. Nothing was done. In that request, pursuant, we still haven't heard any reason why this assumption was made, because the practice book pretty clearly says that that's wrong. It is what it is. Thank you, Your Honor.
All right, gentlemen. I'll look at the papers again, and I'll have a decision out very shortly. Okay.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
All right. All right. You gentlemen have a good day.
Thank you.
All right. Bauer versus Goodman. Parties here on that could identify for the record, please.
Good morning, Your Honor. Daniel Possessor from Wigan and Dana for the plaintiff.
Good morning.
Good morning, Your Honor. Ryan Togas of Ivy Barnum and O'Mara for the defendant.
Good morning.
I don't know if I should say hello. I'm Taru M. Bauer. Good morning.
Hi, good morning.
Good morning.
Just give me 1 second, okay? All right. So this is regarding my order of 1031. I'm assuming that per my order, if plaintiff receives full compliance prior to hearing, the matter could be marked off. The matter's here and we're here. So I'll give it to you, Attorney Passer, to fill me in.
Yeah. Thank you, Your Honor. And I wish we could say that we had received full compliance and marked off the hearing. And I know nobody likes discovery disputes, but unfortunately, I think we have some pretty egregious discovery conduct here by the defense. And I'm going to run through the background to show how we arrived where we are. But the punchline is going to be that in response to 37 requests for production, which were served in April, the defendant has produced an excerpt from one document that is less than a full page. So less than 1 page. We originally served document requests here on April 28th. Those are on the record as Exhibit 3 to docket number 112, which was our original motion for an order of compliance. The deadline to object was June 27th. No objection was filed. No response was filed. On July 11th, we informed defense counsel that they missed the deadline and requested a date by which they produced the documents. They said that they told us at that point they don't object to the requests or the interrogatories, and they said they would produce responsive documents but didn't specify a date. So on July 22nd, we filed a motion for an order of compliance. That's docket number 112. And then on August 14th, 2 months late, the defense filed objections to the request for production and an objection to our motion. They objected to request 20, which requests all documents related to 30 Field Point Drive, and said that the defendant is withholding documents, plural, pending further order of the court. They objected to document requests 24, 25, 26, and 36, which seek all documents related to the defendant being a trustee or acting in trust, and said again that the defendant is withholding documents, plural, on the basis of those objections. They objected to request 28, said documents that may be responsive to this request are being withheld. And finally, on request 34 and 35, which seek copies of defendant's tax returns, they objected that those were overbroad. So we filed a reply on September 2nd, that's docket number 121, saying that those objections are waived because they weren't made timely, and then responding to them on the merits. And the court heard argument and then rendered a decision, as you said, on October 31st, overruling the defendant's objections to request numbers 20 through 28, 35, and 36, and ordered the parties to meet and confer about request number 34. So on December 1st, we did get a response to those document requests, and I do mean those. So to be clear, plaintiff has served 38 requests for production. The defendant responded to none of them. And then 2 months late, and after we had filed our motion, they belatedly objected to 12 of them. The court overruled those objections and ordered the defendant to respond to 11 of those ones to which they had objected, to meet and confer about the 12th. And then the defendant's response on December 1st was to just the 11. So they've still
was to what?
Was to just the 11 requests as to which the court had overruled the objections. So they have still not responded to the 26 requests to which they have never objected.
So the 11. Wait.
That's that,
so,
Judge. That's that. I'm sorry. I have
wait.
to interrupt
Wait a minute. Let me just ask a question. So, are you saying that the order that I entered on the 31st, which is I have in there 20, 21, 22, 24, 25, 26, 27, 28, 35, and 36 that you've gotten full production on?
No, not full production, but we did get a response.
All right.
I mean, I'll turn it over to Mr. Tugas.
Well, let me ask some questions. Okay. So you've got some production on those, but not full production. And you're saying that all the others that we didn't address, or I didn't address in this order, that you've got nothing.
That's my understanding, unless I missed an email. Mr. Tugas seems to think otherwise.
Okay, and then let me ask, what happened with 34? Did you confer on 34?
We did. 34
was what, the tax returns?
So there are two that request tax returns. One, the plaintiff in this case is the defendant's daughter. So one of the requests is for all of the tax returns that were filed, on the plaintiff's behalf by the defendant, and then the other one is for all the tax returns filed by the defendant. So the court ordered compliance with the first, all tax returns filed on the plaintiff's behalf. The defendant's position is they don't have any responsive documents. And then we did meet and confer with respect to the other one. Their position is that the defendant only has recent tax returns, doesn't have any from the 1970s and 1980s, which would be relevant. And the recent ones they contend are irrelevant. We disagree with that. But what I asked Mr. Tugas, like, which years does she have, which are still in her possession or control, so that we can define the universe of documents that are still in dispute. And he said he would ask his client, which, I mean, I think it was concerning that he had not already attempted to obtain those tax returns. But I still don't have a response to that question. So I don't even know which the defendant continues to have.
All right. Let me ask you, I mean, you would agree that getting tax returns from 45 years ago, is that reasonable?
Well, in this case, the relevant conduct happened between 1977 and 1985. So that's why it is reasonable. In a normal case, no, I wouldn't think that would be reasonable. But the argument here is that she wasn't aware of the trust. She wasn't aware of this property. There's a dispute as to how much money she was deriving from it. So I think that the tax returns from back then are relevant for that reason, as well as to show her, to rebut the defense that she doesn't speak or read English, and she doesn't understand the trust documents.
And what would be your argument about obtaining those documents in terms of? Are you of the opinion that she personally saved tax returns from the 70s?
I don't know that I have the information with which to form that opinion. If she filed them through an accounting firm, I would certainly ask the accounting firm if they still have copies. But I'm not here to dispute.
I understand. I'm just trying to I'm not trying to be sort of argumentative or anything like that. I'm just tax returns from 45 to 50 years ago seem like a challenge. In some cases, I would argue that tax returns from a lot earlier than that can be a challenge. I mean, you were talking about an accounting firm. An accounting firm may not even be in business anymore.
Judge, may I be
50
heard?
plus years ago? You can.
They subpoenaed the accounting firm that prepared the defendant's taxes during that period of time. The accountant who prepared those taxes
who did?
The plaintiff.
Okay.
Subpoenaed Walter McKeever, the accountant who prepared the defendant's taxes during that period of time. They don't exist. And I'm sorry, since we're on the record, I have to go back and correct the record here, because there's been no egregious discovery misconduct as asserted by counsel. There's a notice of compliance with the plaintiff's discovery. That's at docket entry number 123. That's September 26 of 2025. The plaintiff's discovery was complied with. And with respect to the court's JDNO notice from November 3rd, directing the defendant to comply with the requests that were the subject of the hearing on the motion to compel on October 31st, the defendant filed a verified response to those requests for production. The defendant verified her responses to them. That's not required, but she said, I don't have documents. They don't exist. So, I think that there's some implication here on the plaintiff's part that because there are no documents, the defendant's concealing them. That's not the case. And the defendant has filed a notice of compliance. The defendant has verified her responses. They don't exist. The only outstanding issue right now is, I believe it's request number 36 that seeks some 45 plus years of all of the defendant's tax returns. And we did have a good faith conference on that on December 1st. And we are trying to find out the universe of documents that we're talking about.
What is your understanding on those documents and how far they go back or that you could obtain?
So the defendant doesn't have them. They're in the possession of the defendant's accounting firm, which is also under subpoena by the plaintiff for Wednesday. I had a brief call with their legal counsel last week while I was on trial, and they are checking to see how many years of tax returns they have. But they believe, and that they are going to confirm it today, but they believe it's from 2018 until present. And as plaintiff's counsel just acknowledged, the relevant time period here is from 1977 to 1985. So whatever is in the defendant's tax returns from 2018 to present is completely irrelevant. And I will note, Judge, that the defendant complied with the plaintiff's request for production for any tax returns showing the plaintiff as a dependent, which don't exist. And frankly, the defendant hasn't claimed the plaintiff as a dependent since she reached the age of majority in, I think, 1991. And any tax returns that show, or any trust tax returns or anything related to trusts, and the defendant doesn't have those either. Those don't exist. So, there's the plaintiff's argument is that, there's this whole universe of documents that hasn't been produced. That's not the case. The defendant has spent a lot of time searching for records and contacting accountants and trying to find records in response to these requests. They do not exist. And I'll say it again because I think it's an admission on the plaintiff's part. The relevant time period here is from 1977 to 1985. That's it. And those returns simply don't exist.
Okay.
Can I respond to that, Your Honor?
Yeah, let me just say, I guess my question is, what do you want me to do if he's saying he's spoken with his client and they've delved into it and there's just no documents that she possesses regarding the information you're looking for, and me and myself knowing that you're talking at a minimum of 40 years ago. I've read an extensive amount of the pleadings here. I'm familiar, with Attorney Peluso, very familiar with Attorney Peluso. Attorney Peluso has passed away about 2 years ago. And I'm not sure if you could have got a document from Attorney Peluso, even if Attorney Peluso was still living, just from my knowledge of of how Attorney Peluso kept his records. I worked for Attorney Peluso for a little bit of time, so I'm very familiar with him. So that's my question. It's like, if he's an officer of the court and he's telling me that he's had these conversations and he just doesn't have them, what am I supposed to do?
I understand that completely, Your Honor, and the answer is on this motion, nothing, because this motion was a motion for compliance with our discovery responses. The court ordered that, and I understand to the extent that the defense position is we have complied, that's their position, and any further motion that we would make would be for sanctions or for discovery misconduct. We'd have to develop a different record for that and submit something else to the court. So I understand that. We are asking for a few things, but I also want to, what I'm asking the court to do today is, one, order the defendant to produce all tax returns in her possession or control in response to request number 34, which is the only request with which she has not already been ordered to comply.
All right, in her possession, are you saying that that she physically has, or are you saying that she can obtain from her? Because you have a subpoena out there of her accounting firm, right?
So the accounting firm has responded to that subpoena and said, all the documents we have that are responsive to the subpoena were collected for the purpose of preparing tax returns and are protected by federal law. So we need either the consent of the defendant or an order from the court to produce them. So I still have a request. My question to the defense counsel was, are you going to consent or do we need to seek a court order? I think they're still trying to figure that out. So I'm not asking for a court order to the third party today, but I that's something that could be forthcoming if they do not consent to that. I also think those tax returns are in the defendant's control because they are withheld by her accounting firm, and she could release and produce those. And I understand that Mr. Tugas says he filed a notice of compliance on the docket with the other requests. I don't have any documents in response to any of the other requests. And if I've missed them, I'm certainly open to being corrected on that. But my understanding is that no documents were produced except for this portion of one page that was produced on December 1st in response to those document requests. And I want to correct the assumption that these documents are all from 40 or 50 years ago and would be hard to obtain. One of the requests that the defense was ordered to comply with was for all documents relating to 30 Field Point Drive, which is a home she currently owns. We got a portion of one page of a closing statement from when she purchased it in 1981. Now, I think anybody having one page of documents about a house they've owned since 1981 is very unlikely. But in this case, the defense has represented that, and it's not wrong, that they listed that property for sale. And they were, in fact, they've said that they were, in fact, in contract to sell it at the time that we made the motion for a prejudgment attachment, which ended a prejudgment remedy, which stopped the sale. So in their motion to dissolve the prejudgment attachment, they say that, I'm going to quote, at the time the PJR order was entered, defendant was in the process of selling 30 Field Point Drive. Defendant had terminated leases for 30 Field Point Drive, which collectively generated rents of $20,000 a month. It was under contract to be sold with a closing date set for June 12th, and defendant is incurring carrying costs of $50,000 per month. So where are the leases? Where's the contract for sale? Where are the rent receipts? Like, there are clearly documents that are responsive to this request that were not produced. So I don't have confidence in the search conducted by the defendant. Again, I'm not accusing Mr. Tugas of hiding anything, but I do not have confidence in the defendant's search for her own records here.
Judge, that's a good point. And I will go back and I will ask our client for that. Part of the issue here is, and it's not Attorney Passer's fault, it's Attorney Mershman's issue. He refused to have a good faith conference with us on our discovery objections and instead filed the motion to compel that we're still arguing 2 months later. I did have one good faith conference with Attorney Passer, but it never addressed these issues. It's hard to interpret a request for all documents related to 30 Field Point Drive. If somebody had answered my telephone calls, returned my emails, returned the voice messages that I left for them, and said that they were looking for this information, I would have asked our client specifically about it. And I will go and do that now, because that makes sense. That's part of our claim in this case. Okay, but it's hard for me to play a game of hide the ball. It's hard for me to sit here and have Attorney Passer say that he's going to file a motion for sanctions because he knows that there's some documents out there that we haven't produced, when we've engaged and our client is engaged in a good faith effort to locate and produce documents. Now, with respect to the tax returns, Judge, I hate to go back to our objection, but we do cite authority in our objection that there has to be a compelling need for disclosure of this information. And that's from Gonzalez versus Walter D. Sullivan Company, 2014 Westlaw 3584570. It's also in Ulaw versus Brooklawn Country Club. That's in the Connecticut Law Reporter at 44 Connecticut Law Reporter 413. There has to be some sort of compelling need for the disclosure of this information because it can't be found anywhere else. And our objection to the request for tax returns is twofold. One,
and which request is that? Are you speaking
36,
specifically
Judge.
about 30? Okay, 36.
36.
Okay.
And our objection to that request is twofold. One, the information is not and cannot be relevant. Two, there's no compelling need or particularized need for the disclosure of that information. This case has nothing to do with what took place between 2018 and 2025. And our client has already engaged in a search for and contacted accountants for tax returns from the relevant time period of 1977 to 1985, tax returns showing the plaintiff claimed as a defendant, and tax returns showing trust income, and none exist. Now, again, it feels like I'm playing a game of hide the ball here. So, and I know that the plaintiff has done a lot of investigative work. They've hired an investigator. I know they've served a lot of subpoenas. So I can only tell you what our client has and what our client has looked for. If there's other information out there, tell me about it, and I can confirm whether our client has it. But it's very, very hard to be playing against a black box.
If I could respond, I'm just going to address the relevance of the more recent tax returns. Again, the defendant has claimed that she was, getting rental income from 30 Field Point Drive, and she's also made some pretty egregious mathematical, or monetary questions about that she overestimated the value of the plaintiff's education by hundreds of thousands of dollars that she paid for. She overestimated rent for the plaintiff by a significant amount of money. And I just think in light of the representations made by the defendant, again, I'm not just casting aspersions on Mr. Tugas, we have a right to see if she was actually gaining $20,000 a month in rental income from 30 Field Point Drive, which should be reported on her more recent tax returns.
But there's another way to find that out, Judge, short of the tax returns. There's no compelling need for the production of the tax return in that situation. It could be from rent receipts.
Yeah, I mean, what about that? I mean, if you could turn over the lease and.
Again, those documents weren't even specifically requested. It was just a broad request for all documents related to 30 Field Point Drive. There's no request for leases. There's no request for rent receipts. So,
well, that would be a document related to 30. If she's renting the property, a lease would certainly be a document responsive to that request, right?
Sure, but we lodged an objection because it's hard to interpret that, and no one would confer with us. So,
well, here's the problem. Here's the problem I'm at, right? So it's like you launch an objection clearly outside the time frame of launch. So what now? So that's I'm faced with you didn't procedurally object correctly, right? So I'm trying to come to do this as judiciously or fairly as possible here. But I mean, the fact that you didn't object within the time frame really left me no choice but to make an order here. Now, what I want to do now is to try to get to a point where there's compliance, but I also understand your position, Attorney Tugas, in terms of the age and as such. So I'm just trying to get to a point where the documents that you do have that are responsive to the requests are turned over. And I tend to agree that when he says any document regarding to the 30 Field Point Road property, I mean, I understand it's pretty broad, but you could sort of, common sense not narrow that down as to what's a responsive document there. And certainly a lease or a payment, a rent payment or anything like that would be appropriate. Now, if you haven't turned a lease over that would tell him what the rent is and as such, what's left for him to do besides ask for the tax returns? Because the tax returns is going to have a schedule of those payments, right?
Sure. I don't know that the tax returns will have a schedule of those payments. I don't know if those payments were received by the defendant individually or went to a company. I'd have to confirm that. But I understand what Your Honor is struggling with, which is, we're trying to comply. How do you get us to comply? And I think the answer is order us to confer in good faith on specific documents that the plaintiff wants but didn't receive. And I understand that our discovery objections were late, Judge. We were trying to comply with the plaintiff's discovery request. I can't contest that, and I'm not going to. But there's nothing in the practice book that says that those objections are automatically waived if they're not filed within the specific time frame. And the plaintiff only cited one case from a different judicial district, from the Superior Court that was, by my recollection, a couple decades old, that held that discovery objections are waived if they're not timely filed. So I don't want to relitigate that. But
listen, I'm gonna just like I don't care, right? Because the way I'm looking at it is the way I look at it. If the objections are not made timely, then I'm going to rule as how I'm going to rule. So, but like I said, I still want to get to a point where there's some common ground here. Attorney Passer, is there a list of documents after my order of the 31st of October that you've received and as opposed to what you have not received?
There's one portion of one page of a closing statement from the defendant's purchase of 30 Field Point Drive is the only document we've received.
Okay.
And that's what she has from her purchase of 30 Field Point Drive, Judge. And again, the plaintiff's allegation here is, they're trying to chase $250,000 from 1985 or 89 forward in time. They've got a $15 million PJR attachment on 30 Field Point Drive, based on an inflated number of $275,000 for that closing back in the 80s. And they've applied a dubious interest calculation to claim that now it's $15 million. So again, if we're tracing the money from that closing in the 80s, and the allegation is that that money went to 30 Field Point Drive, you have the closing statement or what our client has left from it. But with respect to our client's counterclaim, that money didn't go to 30 Field Point Drive. It went to the plaintiff. So that's why you're seeing numbers adjusted for inflation for expenses that were paid by the defendant for the plaintiff. So the money didn't go to 30 Field Point Drive, Judge. That's just one of the defendant's assets that's attached to secure a potential future judgment.
So the money from the sale of the property back in 1985, you're saying it didn't have anything to do with 30 Field Point Road?
No,
Drive,
it was spent. It was spent on the plaintiff, Judge.
Mm-hmm.
That's disputed, Your Honor. Our position is that money was used to pay off of certain liens on 30 Field Point Drive. Again, liens which we have not received any records of.
Liens which never existed, I don't think. But what liens? Ask me for documents related to the payment of a mortgage, the liens.
We did ask for that, and the defendant's response, again, I'm not casting aspersions on Mr. Tugas, the defendant's response is that she doesn't have any such documents. But regardless of whether she has them or not, they are publicly available.
Yeah, I guess I'm in the position to say that there's documents that she might not have, but there's certainly documents that are obtainable, right?
Yeah.
So some things, yes, Judge, from accountants. Other things, if we're looking at bank statements from the early 1990s, those aren't going to be obtainable. Those banks
let me ask you
anymore.
this, Attorney Password. Let me ask you this. So, I mean, rather than I could go back and go through this piece by piece and see, you're indicating to me you've gotten like half a page of document in response to the requests that were subject of my order, right? I mean, I could go back and look at every one of those requests and I could form another order, which would likely order the defendant to turn over documents. And then I think I said this the last time, and then the defendant is going to say, well, I don't have those documents. and we're going to go around in this big circle. So if I did take Attorney Tugas' suggestion and say that you are to confer in good faith regarding all of these requests, is that something that you think is going to get anywhere from your point of view or in your side?
I don't know if it's going to get anywhere, but I don't have an objection to trying with respect to the request that the court has already overruled the objections to and ordered compliance. We can confer about the scope of that compliance. I agree with the court. There isn't much left for the court to do. You've already ordered compliance. And
right,
so
right. I know, but it's like I can order compliance, right? Because I look at it, well, he didn't do it procedurally, he didn't, and then so and this was what I was trying to make the point when the last time we were here. It's like, and I said I don't. It was different counsel, I believe. Not you weren't here at that, or you may have been, but weren't arguing. But I said, it's like I understood that the objections were not timely made, and I said, okay, they're not timely made, which is something that I obviously consider. But if I make just random orders of compliance, aren't we going to be back here in a couple of weeks arguing the same thing? And here we are back here arguing the same exact thing, because he's going to say, we look for the documents, she looked for the documents, she doesn't have documents going back 40, 50 years and things like that. So my feeling is that if I tell you to meet in good faith, which I will reiterate, good faith, Attorney Tugas, to try to come to an agreement. I think I don't know, but I certainly think there's documents out there that can be produced, right? Might take a lot of legwork, and might take legwork on the part of your client, but she's got to do it. right? So I don't see any alternative here but to have you guys sit down or at least talk and say, hey, okay, this is what I asked for. What's your position on this? And, and then come back to me and say, Attorney Passer, you think, well, that's a bunch of BS, you can get those documents, then we can sit down and talk again. But I think we got to have a starting point here. I should have probably done this the last time. Okay.
Yeah, that's fine by us, Your Honor. We'll confer with the defense, and I think if the motion that we are currently here on, in my view, has been exhausted with the exception of the tax returns that we don't have an order on, and there would be a separate motion if there's something else that needs to happen here. I think the relief has been granted by the court to the extent it can be granted.
All right. Well, I'll say sit down and discuss everything. As far as the tax returns goes, I think they're relevant in terms of your argument, Attorney Passer, that if the house is being rented at exorbitant amounts of money, then and there's no other documentation, then the tax returns are certainly going to be relevant. And you may argue that, well, there is no schedule of those rents in the tax return. Well, we're not going to find out unless we get the tax returns, right?
So, but that's if there's no other documentation, Judge, and we'll go and look for that documentation. Which, candidly, we haven't done, because that's not what I understood all documents related to 30 Field Point Drive to mean. I understood it in the context of the plaintiff's claim, not in the context of the defendant's counterclaim, and that makes sense to me now that somebody's said it. The problem was that, and it's not Attorney Passer's fault.
Well, I'll let you both discuss that in terms of whether or not the documents you can produce with regards to the rental of the property are going to be sufficient to satisfy the plaintiff in the case. And if not, we'll be back here and we'll be having these arguments again. But, we're not talking 30 years ago, 40 years ago on the rental of the property. There should be, especially, I'm familiar with Field Point Road area too. I know that there should probably be a lease for a house on Field Point Road. So I'll leave it at that.
Thank you, Judge.
All right. Anything further?
I do want to just clarify with respect to the other request for production. Is the defendant's position that they have been responded to and documents were produced? I just want to clarify that because I have not seen the documents.
So there was a production, but it was a short production. It might have been 3 pages with the initial response. But to the extent that you're looking for documents that were not produced, I'm happy to get on a call and to go through them one by one and tell me what you're looking for if it hasn't been produced.
Well, when I say best efforts, I mean best efforts has got to be, there's, if we're talking about closing documents from 1985, there's got to be some investigation and some digging for those documents. I don't know who did the closing or what the situation was, but it can't be just, well, that was 1985 and we don't know.
Now, the closing statement for the subject property that was allegedly held in trust, that was produced. And that was in the possession of the defendant's real estate counsel. So
well, my point is good faith efforts means there's got to be obviously some rolling up the sleeves and trying to find the documents if they can be found.
Right. Yep. That was in the possession of Attorney Harch, and Attorney Harch had that one closing statement left from 1985, and he turned it over, and we produced it. And we've actually filed it with the court.
All right. I'll just enter an order out that you confer in good faith, and then I'll put another hearing date on it to report back on. Okay.
Thank you, Your Honor.
Thank you, Judge.
All right. Listen, you guys have a good day, and I hope not to see you before the holidays. But if I don't see you before the holidays, you have a great holidays. Okay.
You too, Your Honor. Thank you very much.
Thank you, Your Honor. You
All right.
too.
All right. Take care, guys. All right. Bye now. All right. We can go off the record. I think we have another matter scheduled at 10:30. So, and that's on
Yes, Your
another
Honor.
link. That's on another link. So I'll. All right, thank you. So, good morning. This is the matter of Abedin Dervishi versus Miriam Afif. If the parties could identify themselves for the record.
Atëherë kjo është çështja e Abedin Dervishit kundër Mariam Afif. Ju lutem palët të prezantojnë veten.
This is Mr. Dervishi, plaintiff, and I'm asking for defender. I don't see that here.
All right. Well, first of all, good morning, Mr. Dervishi, and let me just indicate for the record that Mr. Dervishi is going to be assisted today by the Albanian interpreter. Good morning, Mr. Keller.
Good morning, Your Honor. Michael Keller of Morrison Mahoney on behalf of the defendant, attorney Miriam Afif.
All right. Thank you. Mr. Dervishi, I didn't hear you. Do you want to repeat what you were just indicating to me?
Atëherë zoti Dervishi thotë, nuk ju dëgjova, a mund na e përsërisni edhe një herë atë që sapo thatë?
Mirë mëngjes, Honor. Edhe prezantova vetëm Mr. Dervishi dhe po pyes pse nuk shoh defendant Afif here present.
So, good morning, Your Honor. I introduced myself as Mr. Dervishi, and also I was saying that I don't see the defendant here.
All right. Well, the defendant is represented by counsel. Her counsel is going to be arguing the motion to dismiss today. So the defendant is not required to be here today.
Atëherë, e akuzuara thot nuk ndodhet tu sepse ajo po përfaqësohet nga avokati i saj, I cili do të bëjë argumentimin për kërkesën, për ta anulluar, për ta hequr, domethënë këtë akuzë që keni bërë, edhe me ligj asaj nuk I kërkohet që të paraqitet se ka avokatin.
Mund të them diçka?
Can I say something?
Yes.
Unë nuk jam voje profesionist, jam thjesht një person që për përpiqem të mbroj drejtën time. Dhe nuk e di, ndoshta jam gabim, po unë kam disa pyetje për atë. Nuk jam I lejuar bëj pyetje për defendant, mund përgjigjet avokati për.
Okay. So I'm not a professional, but I am trying to represent myself, and I might be making a mistake, but I wanted to find out because I have questions for the defendant. Would I be able to ask her attorney those questions?
No, Mr. Dervishi, we're here today on Ms. Afif's motion to dismiss the case. And her attorney is going to be making arguments on her behalf regarding why she believes the case should be dismissed. Okay.
Atëherë thot, jo zoti Dervishi, sepse ne ndodhemi këtu sot, thot, sipas kërkesës që ka bërë zonja Afifi për ta hedhur poshtë këtë çështje, këtë gjyq që keni ngritur ju, dhe avokati I saj do t'japi argumentimet në emër të saj për arsyeën sepse kjo çështje duhet hedhur poshtë. Kjo ankesë që keni bërë ju duhet hedhur poshtë.
Yeah, but
I'm not finished. I'm not finished.
Një moment, thot, nuk kam mbaruar.
All right. So the only thing that's going to happen today is Mr. Keller is going to argue on behalf of Ms. Afif to have the motion to have the case dismissed. He is going to be arguing to me. You then are allowed to make an argument to me as to why you believe the case should not be dismissed. But all arguments are going to be directed at me, the judge, today. There's no questioning that's going to occur today on either side, okay?
Atëherë thot zoti Keller do të argumentoj në emër të akuzuarës, zonjës Afif, për kërkesën që ka bërë ajo që ky gjyq që keni hapur ju të hidhet poshtë, edhe këto argumentime ai do t'i bëj, do të mi drejtoj mua, dhe pastaj juve do t'ju lejohet e drejta që juve të më jepni mua arsyet sepse unë nuk duhet ta hedh poshtë këtë kërkesë, këtë gjyq që keni bërë ju, por argumentimet thot do të më drejtohen mua, nuk ka pyetje, vetëm thjesht do jepni argumentim, arsyet sepse mendoni që nuk duhet hedhur poshtë.
Okej, duke falenderuar për sqarimin, gjithë jam confused, sepse ihe kërkoj ndjes. Me sa kuptoj unë, avokati e ka bërë një mocion dhe ka argumentuar mocionin për dismis me shkrim, dhe unë jam përgjigj ka për objection po me shkrim. Nuk e di edhe herë.
Okay, I apologize and thank you for the explanation that you gave. As far as I know and as far as I'm aware, I believe that the attorney has already made the argument for this to dismiss in a written form, and I have given my objection, and in response to that, I don't know.
All right, that is correct. He has filed a written motion to dismiss along with a memorandum of law in support of that. He then is allowed to make an oral argument to the court, as are you. You have filed an objection to the motion. You are allowed to make an oral argument to the court as well after Attorney Keller has finished his argument. So at this point, I'd like to proceed with Attorney Keller's argument. All right?
Atëre thot, po, është e vërtet që ai ka bërë një mocion, një kërkesë me shkrim për hedhjen poshtë, edhe ka futur gjithashtu edhe një memorandum të ligjit për ta mbështetur atë mocion që ka bërë ai, dhe ai ka të drejtë që sot të bëjë një deklaratë argumentuese, argumentim me gojë, dhe ne jemi ndjeni që ju e keni bërë kundërshtimin tuaj, dhe zoti Keller ka të drejtë që të bëjë argumentimin gojor, dhe ju në të njëjtën kohë do të keni po këtë drejtë. Tani thot dua që të vazhdoj më tutje duke I kërkuar zotit Keller që të bëjë argumentimin e tij me gojë.
All right. Good morning, Attorney Keller. You can proceed when you're ready. I would just ask you with your arguments to be aware of the interpreter. All right. Thank you.
Atëherë mirëmëngjes zoti Keller, kur të jeni gati mund të vazhdoni me argumentimin tuaj, vetëm desha t'ju këshilloj që të keni parasysh që kur të flisni të keni parasysh përkthyesen që të jepni kohë asaj. Në rregull.
Thank you, Your Honor. And with the court's permission, I'll ask Madam Interpreter, I'm going to do my best, but if I'm going too long or you need me to break it up, please let me know.
Atëherë të faleminderit I nderuar gjykatës, unë dua që t'i kërkoj unë do të përpiqem të bëj sa më atë që të mundem që të flas shkurt me fjali të shkurtra, por në qoftë se unë thotë shkoj shumë gjatë, do t'i kërkoj përkthyeses që ajo të më ndërpres.
So we're here on our motion to dismiss dated April 30th, 2025. It's docket entry number 103. We have moved to dismiss the complaint on two separate grounds. The first is that the court lacks subject matter jurisdiction over the plaintiff's claims because Attorney Fief is entitled to absolute immunity pursuant to the litigation privilege.
Atëherë thot jemi këtu për atë mocionin që kemi bërë për ta hedhur poshtë këtë kërkesë për gjyq sipas datës 30 prill 2025 me numër 103 dhe unë mendoj thot që ky gjyq duhet hedhur poshtë duke u bazuar në dy pika. Pika e parë sepse kjo gjykat nuk ka jurisdiksion për këtë temë të çështjes dhe zonja Afif ka të drejtë për imunitet.
And the second basis is that the court lacks personal jurisdiction over Attorney Fief because plaintiff failed to follow the process requirements as set forth in Connecticut General Statute, Section 52-48, paren B.
Atëherë thot gjithashtu e dyta është se gjykata nuk ka jurisdiksion personal në lidhje me zonjën Afif në këtë rast, sepse akuzuesi nuk ka arritur që të zbatoj rregulloren ose sipas ligjit të Connecticut të statutit 52 viz 48 paragrafi B.
We did receive a copy of the plaintiff's objection. To respond briefly, we did not reply to that just because I did not want to have an issue where that did not reach plaintiff prior to today's hearing, and I intend to just address any issues brought up in that as part of the argument.
Desha të them gjithashtu që neve kemi marrë një kopje të kundërshtimit që ka bërë akuzuesi. Ne thot nuk I jemi përgjigjur kundërshtimit që ka bërë ai, sepse nuk kemi pasur mundësi që të lidhemi me akuzuesin dhe do t'i shqyrtojmë çfarë do lloj çështjes që mund të kemi për këtë në këtë seancë këtu sot.
Turning to our first argument, Attorney Afif represented the plaintiff's ex-wife in a dissolution action captioned Divershi versus Divershi with docket number FST-FA21-502-4206.
Atëherë thot në lidhje me argumentimin e parë, avokati Afif ka përfaqësuar ish gruan e akuzuesit Dervish në çështjen Dervishi kundër Dervishi me numër FST VIS FA 21-502-4206.
Mr. Keller, are you there? I think he froze up. Mr. Keller, can you hear us? All right, just for the record, it seems that Attorney Keller's camera had frozen. He has left the link at this point. I'm assuming that he is trying to get back on.
Atëherë zoti Dervishi, avokati thot që ngriu ajo kamera e atij avokatit Keller edhe ai nuk ndodhet këtu dhe ne supozojmë që ai po përpiqet që të futet përsëri. Okay, we'll wait.
Your Honor, would you like to go off the record? I know as soon as we remove it, he's likely to come back, but
yeah, if we could just go off the record, and
yeah,
I appreciate it.
Okay, thank you.
One second.
There is no argument set forth in the objection arguing that the absolute immunity or litigation privilege would not apply here, and there are no facts to suggest that the alleged conduct was unrelated to the divorce proceeding.
Atëre thot në kundërshtimin që ai ka bërë për mocionin ton, nuk ka asnjë argumentim ku ai të përcaktoj se në këtë rast nuk përfshihet imuniteti dhe privilegji i procesit ligjor, dhe se nuk aplikohet në këtë rast, dhe kjo nuk është, domethënë, është brenda për brenda procedurës së divorcit.
Unless the court has any questions on this argument, we would move on at this point to the personal jurisdiction argument and rely on our pleadings in motion otherwise.
Në qoftë se gjykata nuk ka pyetje në lidhje me këtë argumentim, ne duam që të vazhdojmë më tutje me argumentimin e dytë, pikën e dytë, që është juridiksioni personal në lidhje me kërkesat tona gjyqësore.
All right. Thank you, Attorney Keller. Mr. Dervishi.
Yes, sir.
I'm sorry, Attorney Keller. You go ahead.
No, that's fine. No, I just said I was going to say we'll move on to personal jurisdiction. I'll do that briefly. That's not a long argument, but I just want to make sure the court didn't have questions on the first part of the argument.
No. Go ahead. Proceed. I'm sorry.
Atëherë do vazhdoj më tutje, avokati thotë, unë thjesht desha të di nëse gjykata kishte ndonjë pyetje për argumentimin e parë, për pikën e parë. Tani thotë do të bëj argumentimin e dytë dhe do të jetë i shkurtër sepse nuk kam shumë për të thënë për këtë.
If the court finds that there is subject matter jurisdiction, our second argument is the court lacks personal jurisdiction because plaintiff failed to follow the process requirements set forth in Connecticut General Statute 52-48 paren B.
Atëherë thotë, në qoftë se gjykata gjen probleme me argumentimin e parë që ne kemi bërë për jurisdiksionin e temës të çështjes, ne thotë kalojmë pastaj në argumentimin e dytë, duke thënë se gjykata nuk ka jurisdiksion personal dhe gjithashtu për faktin se akuzuesi nuk ka ndjekur të gjitha rregullat sipas rregullit të ligjit të Connecticut 52-48 paragrafi B.
Specifically, process was defective because it was made returnable more than 2 months from the date of process, and 52-48 requires that process is no more than 2 months. That the return is no more than 2 months after the date of process.
Sidomos tot nuk është ka qenë defektive procesi që është ndjekur sepse sipas rregullit kthimi duhet bërë jo më shumë se më vonë se 2 muaj, sipas rregullit 52-48, thotë kjo është bërë më shumë se mbas më shumë se 2 muajsh.
The critical information necessary to evaluate personal jurisdiction in this context is the date process is signed and the return date.
Ajo informacioni në lidhje me jurisdiksionin personal në këtë rast ka të bëjë me datën kur është nënshkruar dhe me datën e kthimit.
Here, process was signed on the summons on January 27th, 2025, and the return date is April 1st, 2025.
Atëherë thot procesi nënshkrimi është bërë me datën 27 janar 2025 dhe kthimi mbrapa është bërë me datën 1 prill të vitit 2025.
It's undisputed that April 1st, 2025 is more than 2 months from January 27, 2025, and accordingly, process is deficient as it does not comply with the statute, and this court would like personal jurisdiction over the defendant.
Atëherë thot duket shumë qartë që data 1 prill e vitit 2025 është një periudhë më shumë se 2 muaj mbas datës 27 janar të vitit 2025 dhe kjo do të thotë që procesi ka qenë defektiv dhe kjo do të thotë që gjykata nuk ka jurisdiksion personal në këtë rast.
And with that, we'll rely on the arguments set forth in our papers, along with any response we may have to the plaintiff's argument.
Gjithashtu thot, ne tani do të mbështetemi gjithashtu edhe në përgjigjet që kemi dhënë me letra dhe gjithashtu çfarë do lloj përgjigje që do të kemi kundrejt të argumentimit të akuzuesit.
All right, thank you, Attorney Keller. Mr. Dervishi, you now have an opportunity to make argument to the court on your objection to the motion to dismiss. I'm just going to indicate before you begin, I did read your objection. It makes a number of arguments, but what I'd like you to do today is focus your arguments on the jurisdictional issues that were raised in the motion to dismiss. Okay, so if you could just respond to the jurisdictional arguments made in the motion to dismiss. Okay.
Atëherë, zotë Dervishi, tani do të ju jepet juve mundësia që të jepni argumentimet tuaja në lidhje me kundërshtimin që ju keni ndaj këtij mocioni për ta hedhur poshtë këtë gjyq. Unë thot desha t'ju them që unë kam lexuar kundërshtimin që ju keni bërë me shkrim, edhe aty kishit shkruar një numër argumentimesh, por unë dua që këtu sot të përqendroheni në çështjet juridiksionale që janë ngritur gjatë mocionit, pra të përqendroheni në juridiksionin e çështjeve që janë ngritur nga ky mocion, nga kjo kërkesë.
Okay.
All right, you may begin.
Mund të filloni?
Do të thak, mund ta filloj nga pika e dytë.
Can I start from the second point, since it's fresh?
Yes, however you'd like to proceed. Yep.
Po, si të dëshironi që të filloni?
Okay, duke dashur mos përsëris vetën, nuk jam lawyer profesional, por kam ndjekur ato që kam lexuar dhe këshillat e clerk office, të cilat kanë korrigjuar datën e smajsëmën për të konë.
So I don't want to repeat myself, but I wanted to say that I am not a professional lawyer, but I have followed what I have read and also the advice of the clerk regarding the correction of the dates.
Okay. Basi kam plotësuar summons claim, si quhet, duke qenë që do të sqaroj që duke qenë se në lidhje me Attorney Afif kam një criminal case për një email drejtuar të ajo nga kliente saj, që është include the protection order, isha I detyruar ta shërbenja nëpërmjet marshallit këtë summons.
So I filled out the summons, the claim, also because I have a criminal complaint against Attorney Afif regarding an email that was directed to her by a client regarding
in October 7, 2023, and her client make complaint I charged the criminal for violation.
Mr. Dervishi, we have an interpreter here, okay, to interpret for you. So you make your argument and then allow the interpreter to interpret, and then you may continue.
Atëherë zoti Dervishi thot duhet të prisni për përkthyesen, bëni argumentimin dhe duhet prisni që ata përkthej dhe pastaj të vazhdoni. Your Honor, do you want the interpreter to finish what he was saying earlier?
Yes, please.
Regarding a complaint that a client had sent regarding a protective order, and so I was obligated to use a marshal for that.
John Gallup, Constable John Gallup. It's in Illinois. John Gallup is name. John Gallup. Gallup. Yeah.
Gallup. John Gallup. Okay.
It's in for 3 hours. But I come sure I can extend the next week.
So his name is John Gallup, and for 3 weeks in a row, he extended it and he kept saying next week.
Edhe kur kam shkuar herë në fundit que clerk office kan ta går atje dhe clerk office bëri correction se duhet të jetë dita e 8 han data e returning.
And so then when I went to the clerk office, and I complained about it, the clerk office made a correction, because I believe it was the return, was supposed to be on a Thursday or a Monday.
Yeah, return date to be Monday or Thursday, they said to me. The second question is, Attorney Kelly said the defendant get late than 40 days. I'm worried because the motion for dismiss.
Mr. DeVici, we have an interpreter here, okay?
I'm sorry, I messed up myself. Attorney, the motion for dismiss, as it's on que can mark the March 4th. Can mark motion by a claim the March 4th. Is it the CDR, Mopax, and do the Sayar did, 3 years did.
So the motion to dismiss, the date is March 4th, which is less than 60 days. It's 36 days.
Nuk e kuptoj këtë. Qofse e kanë marrë March 4, se e hedhin poshtë jo jurisdiction.
Since they received it on March 4th, I don't understand this. Why are they objecting to this, saying there is no personal jurisdiction?
Mund përgjigjet avokati Kelly për këtë?
Can Mr. Attorney Keller respond to this?
No, Mr. DeVici. As I told you earlier, there are no questions here today. These are arguments made to the court. You can make an argument to the court as to why you believe the motion to dismiss should be denied. Okay?
Atëherë thotë jo, siç ju shpjegovam përpara zotit Dervishi, nuk do bëhen pyetje, thjesht këtu ju do të jepni argumentimet tuaja sepse juve besoni se kërkesa, mocioni për ta hedhur poshtë duhet unë t'ja mohoj atyre këtë kërkesë. Na argumentoni ju këtë.
Duke kërkuar ndjesë, do të po them, kërkoj që kjo pikë e mocionit për dismiss të hidhet poshtë për arsye sepse e para nuk jam unë përgjegjës në qoftë se marshalli Konstantin vonon returning date.
So
Dhe dyta në qoftë se kanë marrë March 4, është brenda një ditë të muaj.
Okay, so first of all, I would like to, for you to consider that this motion to dismiss, the second point, to throw it down, first of all, because it's not my fault that the marshal took too long to deliver it, and then secondly, they received it on March 4th, and March 4th is less than 60 days.
Do you have any further arguments, Mr. Dervishi?
Zotë Dervishi, a keni argumentimet të tjera?
Yes, kam për pikën e parë.
I do for the first point.
Go ahead.
Po, vazhdoni.
E para, avokati u shpreh këtu që kanë përgatitur përgjigje të by objection, por nuk kanë patur mundësi ta dërgojnë. Nuk e di cila ka qenë pamundësia, arsyeja që nuk e kanë dërguar.
So first of all, the attorney here said that they were prepared to reply to my objection, but they were not able to send the reply to my objection. I don't know the reason why they couldn't send the reply to my objection.
Wait a minute. Are you indicating that you did not get a copy of Attorney Keller's memorandum and motion?
Apo thoni që juve nuk ju është dhënë një kopje e mocionit dhe memorandumit të zotit Keller?
Është këtë kuptim. Unë kam marrë kopjen e mocionit për dismiss dhe unë bëra objection. Por Mr. Keller u shpreh këtu që kanë përgatitur me shkrim një përgjigje për ajo objection, por nuk kishin mundësi ta dërgonin tek unë.
No, it's a misunderstanding. I have
Okay,
received a
I'm sure.
copy of the motion to dismiss, but and I prepared an objection, and Mr. Keller said here that they read my objection and prepared an answer to my reply to my objection, but were not able to send it to me.
No, I think he indicated that he received a copy of your objection, but he did not file a reply to that objection, which is his right.
Ai tha që ai e ka marrë një kopje të kundërshtimit tuaj, por nuk ka dorëzuar, nuk ka futur në dosje një përgjigje ndaj kundërshtimit tuaj dhe e ka këtë të drejtë. Ka drejtë ta bëj këtë.
Ndoshta kam keq kuptuar, por në atë që dëgjova unë, avokati u shpreh e kemi marrë objection e plaintiff dhe kemi përgatitur përgjigjen, por nuk kemi patur mundësi ta dërgojmë. Kështu e dëgjova unë.
Perhaps I misunderstood, but what I heard him express is that he said that we have received the plaintiff's objection. We prepared a reply, but we were not able to send a reply.
Attorney Keller, you just want to give a clarification again on that?
Zoti Keller, avokati Keller, a mund na jepi një sqarim për këtë edhe një herë? Po patjetër.
We received a copy of the plaintiff's objection.
Morëm një kopje të kundërshtimit të akuzuesit.
We did not draft or file a reply brief to the objection because this argument has already been postponed twice due to issues in papers being exchanged between us and the plaintiff.
Thot ne nuk para përgatitëm edhe nuk dorëzuam një përgjigje ndaj kësaj, sepse thot ky argumentim është shtyr 2 herë për arsye të vështirësive që kemi pasur në shkëmbimin e letrave me akuzuesin.
And accordingly, we are addressing any arguments in the objection during our oral argument today.
Edhe për këtë arsye thot, ne çfarë do lloj argumentimi që ne kemi kundër kundërshtimit të tij, po I adresojmë këtu sot gjatë argumentimit me gojë.
You understand now, Mr. Dervishi?
A e kuptoni tani, zotë Dervishi?
I understand, but I have a question. A supozohet që ata do ta kishin bërë me shkrim, unë isha përgatitur për ato që do ngërinin të kundërshtimet për sot?
Okay, but I have a question. Is it are they supposed to have prepared a written reply to my objection so that I would have been better prepared to respond to their reply to my objection?
No, that is not required. They're not required to file a reply to your objection if they want to make argument based on the arguments that you make today. They can do that, but they're not required to file a written reply.
Jo, thot nuk I kërkohet, nuk janë të detyruar që ta japin një përgjigje me shkrim, ata thot kanë të drejtë që t'i përgjigjen çdo argumentimi që ju mund bëni këtu sot, por nuk janë të detyruar që ta japin përgjigjen me shkrim.
Tashti jam I qartë, po isha confused sepse derisa e përmendi avokati thash mos kishte detyrim të.
I'm clear now, but I was confused earlier because since he mentioned that, I thought that maybe he was obligated to have done that.
Okay, you can proceed.
Mund vazhdoni.
Okay. Avokat Keller në mocionin e tij për dismiss ripet disa herë të njëjtën që po bën dhe sot dhe citon ose I referohet imunitetit absolut the defendant si lawyer.
So Attorney Keller mentions in his motion to dismiss, and he has repeatedly done so, even here today, of mentioning the same thing by quoting or citing the absolute immunity of the defendant as a lawyer.
Ponukje pas një section number ku referohet sepse janë përpjekur të gjej se ku cilësohet që avokati ka imunitet absolut kur vjen thyen betimin e avokatit, thyen procedurat e profesional etik, apo kur contempt, prejudice, kur hajt, kur fshet, fraud, many things I raised in my emotion.
Okay, but he fails to mention any section number or any law that he is referring to specifically when he mentions absolute immunity at a time when the defendant has broken. Okay, that interpreter might have to ask him to repeat the second part. Okay, yeah, has broken the attorney oath, and also has broken the professional ethics by the professional ethics, and by also hiding information.
Hiding, disappear, forger, fraud.
He's speaking in English now, Your Honor.
Sorry. I look at the other ship to the forger.
Forging.
Falsificando.
Falsifying. Also disappearance of evidence and files.
August 9, 2023.
Not only documentation from the court, but documents, not only documents that I sent, but also documents from the court, like the case on August 9.
Exhibit 5. Exhibit 5 from court August 9, 2023.
Like Exhibit 5 from the court case August 9, 2023. There were two exhibits that disappeared that that proved that were evidence.
Apo kur jo vetëm lejon klientën të gënjej e të bëj falsën, por the leading question lead her to lie. Drejton atë të gënjej.
And so also not only allows her client to lie and make false statements, but also through leading questions led her to lie.
Tjetër objection është, kush është arsyeja që avokatja Afif akcepti të asistoj të këtë keq, të drejtoj the leading question në rrugën që ka, kur ishte e qartë që ky keq është fraude të kundërshtim me Title 46B to Family Court. I also support to know to be this legal because a family lawyer, which is kush është arsyeja ajo pranoi të asistoj dhe të djegë këtë keq që është fraud from start.
Fraud dhe ke fjalë fraud?
Fraud is
okay.
unlawful or stream.
Okay. And so the other objection is that what is the reason that attorney Afif accepted to assist in this case with leading questions, and when it was very clear that this was fraud was committed here based on Title 46B, according based on it being the family lawyer, when it was clear that this was a total fraud.
Perché avvocati nu că pot far imuniteti ca avocatia kur fyen betimin e avokatit, si e ka bërë detyrën e avokatit kur fyen betimin e avokatit që thot në qoftë se mendoni të saj, dhe duke ditë diçka është dishonest, is fraud, ajo duhet të ftoj kohën të organet kompetente.
So the attorney here fails to identify what kind of an immunity this attorney has when she has broken the attorney oath and in her job or duty as a lawyer, if she has failed to report to the court when there is dishonesty.
The nurse done by oath, but Connecticut professional rules too. Duke në jojnë atë të asistoj të marrë një case që mendoni është fraud.
So the Connecticut professional rules do not allow her to take on a case where it's clear that there is dishonesty involved.
Këto veprime këto nuk është behind, nuk është brapa çfarë thot klienti. Kjo është detyrë e saj si avokate të zbatoj, të ndjeki betimin, zbatoj profesional rulet dhe të thot klientit saj, your case juaj is not negative, cannot go this way.
So the attorney has her professional duty in her role to follow the attorney oath and the professional rules to tell her client, I cannot take your case. There is no legal. There's no. Your case is not legal.
Si mundet një avokat në eksperiencë në family case, kur shikon një case të signed uncontested, edhe no financiatis for no contested, por ka peticion for joint petition.
I'm sorry, Your Honor, the interpreter needs to ask Mr. Dervishi to repeat one more time. He speaks half in English, half in Albanian, and it's a little bit hard. Edhe njerëz do të Dervishi edhe njerë.
Si mundet një avokat në eksperiencë, kur shikon që një case, një çështje është shënuar ke uncontested, por nuk ka joint petition for uncontested, nuk ka stipulation, kur pada tjetër ka sign for apparence, kur pada tjetër nuk është present, nuk ka për stipulation.
Okay, so how can an attorney that has is experienced in family cases when the case is uncontested, there is no joint petition for uncontested, there is no stipulation, the other party waives appearance and is not present, how can
no way file for apparence. I will file for apparence February 22.
File for
apparence in the court. File. I file. Yeah.
File?
Platsova.
Oh, okay.
Platsova for apparence.
Okay, so when I filed for an appearance in court to be present,
uncontested.
which shows that it's not uncontested.
The courses that your avocatas for only they're going email September 16, që I tregoj. I thuan klientës tuaj të vi, pari fëmijë tunet vi bisedojmë, ndryshe do vazhdoj gjatë. Ndërsa avokatja nuk u përgjigj, e shefi nga gjyqi, edhe është zhdukun në 9 kurs 2023 nga exhibit file.
And so what kind of attorney is she when I emailed her on September 16 and I told her I said, tell your client to get the children when we can sit down and we can talk about it. And she disregarded it, she hid it, and she wiped it out and it disappeared on August 9th. All of that was not shown.
Look at
Right, wait a second. Mr. Dervishi, I'm understanding that you are self-represented, and I'm giving you a lot of leeway in making your arguments today because I'm certainly sympathetic of that. But what I really need you to do is, we're not trying the case today, okay? So I just really need you to focus your arguments in opposition to Attorney Keller's arguments that he made today, okay?
Atëre, zoti Dervishi, unë kuptoj që ju po përfaqësoni veten tuaj, edhe unë po ju jap shumë, me thënë, hapësirë që të bëni argumentimet tuaja. Ne nuk po I bëjmë gjyqjen e çështjes sot. Thjesht unë ju kërkoj që argumentimet tuaja t'i përqendroni në ato që ka paraqitur zoti Keller sot.
Okay. Duke përshëndetur, duke kuptuar horror, I don't remind name, do përpiqem të jetë më brenda asaj mund të shtinë. Por
Okay, I will try, Your Honor, to do my best to stay within that.
Unë po përpiqja të tregoja që ku qëndron imuniteti absolut I avokatës doktoras dhe ku I referohet.
So what I was trying to say is, where is this absolute immunity based on, this absolute immunity of the attorney? Where do you find that? What is it based on?
Avokati Keller tha që avokatja ka bërë detyrën për klientën e saj, behind the business.
So Attorney Keller said that the attorney, she did her job for her client.
Dorsa unë them që avokatja nuk e ka bërë detyrën behind për klientën e saj. E para.
Whereas I say that she did not do her job as an attorney behind first.
E para, ajo nuk duhet kishte pranuar dhe inkurajuar klientën e saj të vazhdonte një gjyq të parë kundërshtim me Connecticut Judicial Branch.
So first of all, she should not have accepted the case and encouraged her client to file a lawsuit that was not proper according to the Connecticut law.
E dyta, nuk është detyra avokatës të bëj testimoni, të suportoj të gjaq prejudice dhe paragjykimi që defendanti ka paguar për escort service edhe avokatja të testify, gati të testimoni.
Secondly, the attorney should not give testimony to support the prejudice against the defendant that the defendant has paid for escort services. The attorney should not testify for that. She volunteered to testify, to give her testimony for that.
Okay. Tjetër, nuk është për apo klientën e saj që avokatja për të gjetur earning capacity në kundërshtim me gjithë avokatët që ka folur përpara, shprehet tekstualisht në gjykat që ne gjetëm $600,000 earning capacity to justifikojmë $2,500 for monthly payment alimony.
And so another thing is that the attorney was testifying regarding or talking about the earning capacity, and this was against the calculations. And she expressed specifically, she said, we found $60,000, and this was to justify the $2,500 support.
Nuk është detyrë avokatës që drejton pyetje leading question në lidhje me psikologjinë se si mund veprojë unë me familje property in Albania.
So it's not the job of the attorney to ask leading questions regarding the psychology of how I might be acting with family property in Albania.
All right, Mr. DeVici, I'm just gonna say it one more time. As I said, I'm sympathetic that you're self-represented, and you're not an attorney, but you're making arguments that have nothing to do with the motion to dismiss. I need you to address the arguments made by Attorney Keller that addressed whether or not you have personal or subject matter jurisdiction over the defendant. All right. We're not trying the case today, so I don't need any facts of the case and what she may have argued in your divorce proceeding.
Atëre thot zoti Dervishi edhe një herë unë ndjej simpati për juve, thot, sepse ju përfaqësoni veten tuaj dhe nuk jeni avokat, por desha t'ju them edhe një herë, argumentimet që po bëni juve, thot, nuk kanë të bëjnë me atë kërkesën për dismiss, për hedhje poshtë që avokati Keller ka bërë. Juve, thot, po jepni argumentimet dhe kërkesa e tij është që ka të bëjë me temën e çështjes, jurisdiksionin e temës së çështjes. Ju po na jepni argumentime për çështjen në fjalë. Ne thot nuk po e bëjmë gjyqjen këtu sot dhe ne nuk duam që të na jepni fakte në lidhje me divorcin.
Okej, edhe një herë unë po përpiqem të kundërshtoj që gjykata, siç avokati thotë, nuk ka jurisdiksion për arsye se atëherë avokati Afif ka imunitet absurd. Unë them të kundërtën. Jo avokati Afif, po asnjë avokat nuk ka të drejtë, nuk ka imunitet të mashtrojë gjykatën për të thyer betimin, rregullat professional rules, të mashtrojë, të bëjë forgery, të zhdukë dokumenta. Unë nuk e di dhe një, pashë do të specifikoj avokatit, cili seksion e mbron i jep imunitet avokatit.
Okay, so again, I don't agree with the argument by Attorney Keller that the court does not have jurisdiction at a time when Attorney Afif, but not just Attorney Afif, but any attorney had to have absolute immunity at a time when the attorney has committed fraud, has broken the attorney oath, has broken the rules of the professional rules, has forged documents, has not presented documents, has made them disappear, and has used fraud.
Dhe Keller, with respect, cilsoi që avokati Afif si arsye për imunitetin ka vepruar mbas klientes, në drejtëri klientes, por nuk është klientja që ndjek procedurën ligjore, se prandaj e ka hajër e paguan klientja, avokatin, po është avokatja që ka shkipur, nuk ka dërguar judgment order for court December 17, nuk ka dërguar notification for alimony, nuk ka dërguar, nuk e ka njoftuar për January 4 hearing final judgment, nuk ka njoftuar për January 24.
Okay.
Dhe të stopoj të daloj për apil, për 40 ditë limitaj.
Për çfarë? Për
duke bërë këto, duke mos njoftuar, unë isha jarë djeni, pikosht isha në Albania, isha në Shqipëri, dhe për u ktheva unë në mars, kishin kaluar 40 ditë dhe unë nuk ka apeloja do.
Okay, so Okay, so Mr. Attorney Keller presented that Attorney Afif was doing her job as a lawyer to her client, but it's not the client that's the one who follows the legal procedures. That's why the client hired her as an attorney, because she's the one that knows the legal procedures, and she purposefully did not notify me about the December 17 hearing, also January 4 and January 24 regarding the alimony. I didn't receive the notifications. At that time I was in Albania, and I missed out on the time frame for filing the appeal, which was within 40 days. By the time I came back from Albania, it was more than 40 days.
Ishte bërë intentionally me kastine që unë kisha dhe shprehu aty në...
This was done intentionally against me.
A ka imunitet në të rast avokatja?
So in this case, does the attorney have immunity?
Pra, kërkesa ime është gjykata, honor to dismiss, motion for dismiss and proceed in my claim, in my allegation.
So my request to the court is to dismiss the motion to dismiss and to proceed with my complaint.
All right. Thank you, Mr. Devishi. Attorney Keller, if you want to respond in any way, you're more than welcome.
Atëherë faleminderit zotë Dervishi, avokati Keller, nëse ju doni të përgjigjeni, mund të përgjigjeni.
Thank you, Your Honor. Just very briefly, I have nothing further to add with regard to our personal jurisdiction argument. It would stand on our papers and prior argument on that.
Atëherë, shkurtimisht, i nderuar gjykatës, unë nuk kam asgjë për të shtuar tjetër në lidhje me atë pikën për jurisdiksionin personal. Unë vazhdoj të qëndroj, domethënë ta mbështes atë duke u bazuar në letrat siç paraqiten nëpër letra.
With regard to plaintiff's arguments on subject matter jurisdiction, I did not hear anything that would negate our position that absolute immunity attaches to the conduct alleged here. I would point out that our Supreme Court in Sims v. Seaman very explicitly held that absolute immunity attaches to allegations of fraud.
I'm sorry, Attorney Keller, what was that case that you quoted from the Supreme Court?
Certainly, Sims, S-I-M-M-S versus Siemens.
Okay. Atëre, në lidhje me pikën tjetër për sa i përket jurisdiksionit të temës çështjes, unë mendoj që akuzuesi nuk ka dhënë asnjë arsye që ta anulloj ose ta eliminoj ato që ne kemi thënë, sepse ekziston mbështetje ligjore për sa i përket imunitetit absolut, dhe këtu do të citoja atë çështjen gjyqësore nga gjykata e lartë Sims kundër Siemens.
And I think all of the argument that I just heard from plaintiff only highlights that the allegations here very squarely relate to conduct and statements made during the underlying proceedings in the courtroom or preparatory to that.
Atëre thotë gjithashtu të gjitha argumentimet që unë kam dëgjuar nga akuzuesi këtu sot në lidhje me deklaratat që janë bërë, këto I referohen të gjitha të gjithë sjelljes, veprimeve dhe deklaratave që janë bërë gjatë procedurës gjyqësore ose në sallën e gjyqit ose gjatë periudhës parapërgatitore.
The comments, the objection to the
Okay. Can I add a couple of small things about this?
Mr. Keller's not done. You can, I'll give you an opportunity.
Okay. Një moment, do të sa të mbaroj zoti Keller se nuk kam mbaruar, ai do t'ju jap mundësinë mbasi të mbaroj.
Briefly, the citation in the objection and argument today concerning the rules of professional conduct, when those speak of jurisdiction, they're speaking of jurisdiction over the disciplinary authority of the state of Connecticut, not anything related to the issues before the court today.
Atëre thotë në lidhje me citimin në kundërshtimin që është bërë për argumentimin në lidhje me thyrjen e rregullave të sjelljes profesionale, në lidhje me jurisdiksionin, ato nuk kanë të bëjnë me çështjet për cilat po flasim këtu sot, por kanë të bëjnë me ato rregullat disiplinore sipas statusit të Connecticut.
Further, I would just point out that the preamble to the rules of the professional conduct is very clear that they are not designed to be bases for civil causes of action in this state. And even if they were grounds for a cause of action, that has no bearing on whether the litigation privilege and absolute immunity applies in this instance.
Atëre thot gjithashtu në hyrjen e rregullave të sjelljes profesionale, thuhet që kjo nuk mund të bëhet bazë për veprime civile sipas statutit, pra në këtë çështje gjyqësore, këto nuk janë bazë dhe nuk kanë ndikim në imunitetin absolut.
I have nothing further at this time. Thank you, Your Honor.
Nuk kam asgjë tjetër në këtë moment, faleminderit I nderuar gjykatës.
All right, thank you, Attorney Keller. Okay, Mr. DeVici, I'm going to give you a few minutes just to respond. Yeah. I'd ask you to be brief and just address the comments made by Attorney Keller. Thank you.
Atëre zoti Dervishi do t'ju jap pak minuta që të përgjigjeni dhe ju lutem thot sa shkurtimisht, thjesht duke u drejtuar atyre që tha zoti Keller.
E para unë bëra një pyetje, cili ligj edhe cila gjykatë ka jurisdiksion mbi avokatin dhe nuk mora ndonjë përgjigje nga avokat Keller, cili seksion.
So first of all, I asked the question, which law or which court has jurisdiction over an attorney? And I didn't receive, or which section, I didn't receive a response from Attorney Keller.
Well, no, wait, Attorney, I'm sorry, Mr. DeVici, as I indicated, today's not a day to be asking questions, okay? Today's a day for arguments, so you can address your arguments to the court.
Okay, the argument is, Avocat Keller u shpreh që nga gjykata e lartë Filman I ka cituar në mocion është në suport të imunitetit të avokatit.
The argument is that the Attorney Keller, he also cited them in his motion, Filman from the Supreme Court, regarding the absolute immunity of an attorney.
Ai case I referohet for defamation, The vocabulary for defamation, not for conduct, a
So
violation.
so in that case, that was referring to defamation. It wasn't referring to conduct in a civil matter.
My claim is not for defamation.
My claim is not for defamation.
Edhe një herë kërkoj që gjykata ta denajë the heavy motion for dismissed.
So, and again, I ask the court to deny the motion to dismiss.
All right. Thank you, Mr. Devishi. Thank you both. I appreciate your arguments, and I will have a decision out on this matter as soon as I can, okay?
Atëherë falenderoj
Thank you,
zotin
Honorable.
Dervishi, ju falenderoj të dyve, do ta jap një vendim në lidhje me këtë çështje sa më shpejt që të mundem.
Thank you, Your Honor.
All right.
Thank you, Honor. Have a
All
good
right.
day.
You all,
Thank
you all have a great day, okay? And
I appreciate it. Falenderoj për kohën e për
I would like-
që më gjatë.
I would like to thank you for your time, and I appreciate it.
Edhe
You're very welcome.
And same to Attorney Keller as well.
Ju falenderit, have a good day.
You as well,
Thank
Mr.
you.
all
Clerk.
right. All right.
Okay.
Take care, everybody. We are in recess till 2 p.m. All right.
Okay, thank you, Your Honor.
Court stands in recess.
We are on the record, Your Honor.
All right, thank you. So good afternoon again, everybody. If everybody just could identify for the record, please.
Sure. Good afternoon, Your Honor. Erica Nolan, Hurwitz, Sagrin, and Schlossberg on behalf of Ms. Grant, and my colleague David Schlossberg is here as well.
Good afternoon, Your Honor.
Good afternoon.
Frank Silvestri for the defendants. With me in the room, but not on camera view, is our Associate Attorney, Bianca Burns.
All right, good afternoon. Okay, all right, so just before we begin, it's my understanding, and I just want to confirm that this with all of you, is that we're here on the plaintiff's motion for extension of time and motion for an order of compliance. Is that everybody's understanding?
That's our understanding, Your Honor.
Yes, Your Honor.
All right, so what I'd like to do is just deal with the order of compliance first. So Attorney Nolan, if you would like to proceed whenever you're ready.
Sure. Thank you, Your Honor. The motion for order of compliance that's before you was filed only as a last resort because the defendants have refused to engage in good faith meet and confer efforts and have refused to comply with even the basic requirements of the practice book. The positions they've taken throughout the lengthy history of this proceeding are unsupported by the rules of this court and any Connecticut case law. Defendants have used every tool in their arsenal to delay this proceeding, allowing them to obfuscate and wordsmith their way around the court's lawful orders with impunity. I want to be very clear in this because Your Honor has expressed concerns previously. This is not a fishing expedition. The audit log that defendants finally produced several months ago shows that Dr. Kolker accessed Ms. Grant's medical records 1 full year after she stopped treating with him. This was not a one-time occurrence. This happened 3 separate times in 2023, on July 27th, August 1st, and September 21st. Those dates align directly with when federal search warrants or subpoenas were served on Mr. McMahon, her alleged abuser. Ms. Grant had not treated with Dr. Kolker since April of the year prior and did not serve her initial request for her medical records until the following February. There is simply no reason for Dr. Kolker to have been reviewing Ms. Grant's records at that time, and it is highly suspicious. That fact alone demonstrates that there are likely documents or communications about Ms. Grant's medical records that have not been produced and are being actively concealed in response to her document requests. Your Honor granted the bill of discovery on August 11, 2025, and you found that there was probable cause for Ms. Grant's document requests. Your Honor further ruled that both the medical records and billing records would be produced without objection. The court then confirmed that the defendants may raise objections as to any other document requests, and Your Honor, in fact, ordered defendants to be cooperative in this matter. You went on to say if there are any issues with a time frame or issues that just cannot resolve, submit a case flow request and potentially have a status conference or a discovery conference, and we can address those. The court's ruling was crystal clear, at least to Ms. Grant and her counsel. Medical and billing records would be turned over without objection. The defendants could raise whatever objections they sought on the additional requests. We would meet and confer and raise them with the court if necessary. The defendants have now taken the position that the only thing they were ordered to do by this court is to turn over medical and billing records, nothing more. However, even as to those two categories, defendants cannot justify their lack of production of payment records, which were specifically ordered by this court. Your Honor, at this juncture, what we're asking the court to do is to order the defendants to comply with our discovery requests. We want the payment records produced, which have already been ordered by this court. The defendants did not object to these requests, and they now refuse to produce them. We also would like an order from the court ordering the defendants to comply with the requirements of the practice book, specifically providing a compliant privilege log. Again, ordered by the court and in the text of Your Honor's order, which the defendants have refused to produce, despite raising claims of privilege in no less than 8 of their responses. Additionally, we'd like the defendants to state for each request whether responsive documents have been withheld pursuant to their objections, because they refused to do that. We ask the court to overrule the improper general objection. It's not compliant with the practice book. It alleges no sufficient legal bases on which to object. And finally, we ask the court to order the defendants to actually conduct searches to determine if responsive documents exist as to each of our document requests. At our singular meet and confer conference, defendants counsel was unable to tell us whether any searches were conducted at all, never mind what those searches may have consisted of. As to the individual document requests, Your Honor, we'll reserve our rights. At this time, we can't determine whether the responses are fulsome as to whether all responsive documents have been produced. So we would seek compliance with those individually once we've had more information from the defendants. It's important to note that the defendant's objection to our motion for order of compliance ignores the vast majority of the arguments raised in our motion. But I'd like to address perhaps the most telling admission. Defendants appear to have abandoned in their opposition the argument that the practice book does not apply to this bill of discovery proceeding. However, this argument was raised countless times, both during the singular meet and confer conference, via email, and even before this court at oral argument on defendant's frivolous motion to open the judgment, as Your Honor might recall. This argument has no basis in law and fact and is wholly unsupported by any Connecticut case law. We thought about what would be analogous in this situation, perhaps a prejudgment remedy application. This is a unique statutory pre-action proceeding in Connecticut, requiring the same probable cause standard as a bill of discovery. But no one would argue that the rules of the practice book do not apply to a prejudgment remedy application. Those are the rules of this court. In the same vein, it makes no logical sense that the rules of discovery do not apply to a bill of discovery. As such, defendants cannot make any arguments, and they haven't in their opposition, to excuse their compliance with the requirements of the practice book. Given these flagrant abuses of the system and disregard for the court's orders, we have not yet asked the court to order sanctions, but we ask Your Honor to order the defendants to comply with our discovery request, failing which they will face sanctions. Thank you, Your Honor.
All right. Let me ask you this: in terms of the payment records.
Yes, Your Honor.
Because I know that was something I recall being specifically requested back in August. And I ordered those payment records to be turned over. And I think it was your brief which indicated that payment records were turned over, but it looks like they were billing statements that were marked paid.
That's correct, Your Honor. I would classify them as billing records. So a bill was produced and stamped paid across the top. However, we know, as a matter of fact, that Ms. Grant never actually paid for those services. So we asked for payment records to understand who paid for them, how they paid for them. Was it a card on file? How were they instructed to do that? Because Ms. Grant didn't do that. Defendants have wholeheartedly refused to even identify whether those records exist, never mind produce anything.
Mm-hmm. All right. All right, Attorney Silvestri.
Let me answer the last point first, Your Honor. Not knowing anything about details about how payment was made, who arranged it, who paid for it. We told them we'll stipulate. Vince McMahon paid every single bill. Vince McMahon was a patient of Dr. Kolker's. His credit card was on file. Dr.
All right, well then, I read that in your brief. So then what's the problem? If you're admitting that Vince McMahon paid her medical bills, then show them how Vince McMahon paid the medical bills. I ordered that.
The way it's done is that the credit card information is on file. And when the system generates a bill, it charges Mr. McMahon's credit card automatically. And that's what showed up on the records. We'll stipulate to all these facts.
All right, well, wait a minute. All right, so if there's a bill and Vince McMahon pays it with his credit card, and you're saying that that's what, isn't there a record of that?
Yes, where it says paid. McMahon
Right,
gave.
paid by, yeah, it says paid, but it's going to indicate, correct me if I'm wrong, but I think Attorney Nolan has indicated that it says paid. And we have no idea who paid it or how it was paid.
And we're.
I mean, it might as well have been me stamping it paid.
I don't think you're going to find it because of the way that it's specifically saying paid by credit card so-and-so, because that's not the way the records are kept. McMahon's credit card was on file because he was a patient. When the bill was generated, it was charged to his credit card. That went into the Dr. Kronos system, which generated the paid statement. And
Attorney Silvestri, Attorney Silvestri, when I go to the doctor or when I go to anywhere and I pay a bill with a credit card, right? And I get a receipt, it's going to indicate at least the last 4 digits of the credit card, right?
I believe so.
All right. So then you're telling me that his billing records don't include the last, at least the last 4 digits of the credit card?
All the records that I have seen and requested do not reflect that.
All right.
That it is picked up by the billing, the company that does the billing, prepares the records, the Dr. Kronos company, and they'll apply the credit card payment and generate a document that says paid or paid.
Well, all right. So let me ask you this then. If McMahon is paying the bills, is he getting a receipt for paying the bill?
Not that I know of.
All right, well, let's find that out.
It's not a question I specifically asked, I must tell you, Your Honor. But it's got to be on his monthly credit card bill when it shows up, along all those other credit card charges. I'm kind of mystified as to what the concern is here, given the nature of the allegations that there's somehow McMahon and Dr. Kolker are somehow in cahoots, and we're stipulating that when Ms. Grant began her treatment with Dr. Kolker on Mr. McMahon's recommendation, and McMahon said, "Yeah, charge it all to my credit card."
Well, listen. I don't. It's not for me to speculate what the need is, right? It's like I made the order, right? And what I can speculate on is that a document that she went to the doctor and her bill was paid without any indication of who paid that bill is meaningless. Right?
We agree, Your Honor.
And I don't. What I'll say is, I think you need to dig a little bit deeper into those bills and into those payment records, because I'm not saying that there's any sort of misleading or anything like that going on, but I just find it hard to believe that a doctor is maintaining billing records without any indication of who paid those bills. So
I think
I'm going to issue an order, and one of those orders is going to include compliance with my order to provide the payment records. So whether that is, you're going to have to go back and he's going to have to start, I understand, I'm not trying to, it's not a fishing expedition. I get it, but I've already entered an order. And I think that's why I'm sort of taking the tone that I am. It seems like I've entered an order, and the attitude is that, well, you know, we gave them documents that show the bill was paid, and that's satisfactory.
Oh,
but it's only satisfactory. And again, I believe myself to be the most humble person there is, but it'd only be satisfactory if I said it was satisfactory, right?
It's your honor, your order, your honor. So yes.
Right, and that's why I'm taking the tone I am. That I think that the order is sort of not being taken seriously. We were here, we had arguments. I made the order, and I really expect the order to be followed through with.
If your honor, please, you saw the motion to seal that we filed.
I did,
and part of that, and this much of that, is billing records. So it's not like provide the court with any billing records.
Again, your honor, they're all just bills stamped paid.
All right. Well, as I said, we'll take up the motion to seal. I don't know what everybody's position is on the motion to seal, but in terms of the billing, and it's not the billing / payment records, right? It's the billing and payment records. So there's two items there. That those, whether or not he has to dive in and find out that information, but that's what I'm going to order that he does, because I'm reordering that this be turned over. And I want a good faith effort to locate payment records that indicate who paid the bill. I don't want a record that anybody could just pull out today and rubber stamp paid on it. There was an intent in the request. There was an intent in the order to give over those records.
And your honor, we did produce multiple billing records. We will go back and I don't know what there is because of the way that this is maintained by this Dr. Chrono system, and I'm not sure where the billing is actually made to the credit card company, if it's Chrono or if it's done by Dr. Kolker's office. I imagine it's by the office, but I'm not sure. But this is why we said McMahon paid them all. There's no doubt.
I'm sorry?
McMahon paid them all. There's no question.
I understand that. I understand that. You can say McMahon paid them all, right? But where's the documentation behind that? So there's got to be some documentation behind it, and that's what I'm going to put in the order. So what I would say is, again, he's going to have to look for those documents, or we're going to have to find them, right? Or we're going to have to get a better explanation than all we have is a bill that's marked paid, right? And then I'm going to order that you participate in some sort of good faith discussions with Attorney Nolan as to sort of developing whether or not these, you can make an argument that that you just don't have them, but at least communicate.
I can certainly do that, Your Honor. I will talk to Dr. Kolker. Again, I do know that what happened is that when Ms. Grant was initially referred to Dr. Kolker's office, McMahon said, "You've got my credit card. Put all of her bills on my credit card." And so they did. And each visit to the office didn't generate a repeat of that scenario with McMahon again saying, "Bill it to my credit card."
See, I'm not saying that that's not correct. It just seems to me beyond, it seems a bit disingenuous to say that a medical doctor's office who's got the credit card, listen, I don't watch wrestling, but I certainly am aware of who Vince McMahon is, right? And a man of his means and wealth, I think there should be a paper trail that he's paying for other people's medical bills. I'm not saying that it's 100%, but there should be some sort of record.
I anticipate that to the extent there is such a paper trail, or an electron trail, probably not paper. It may well be that the only way to identify that would be by virtue that there's a credit card number that matches Mr. McMahon's credit card number. And I'm concerned about not having to reveal that credit card number. And I'm trying to think of ways to do that satisfy Your Honor while not putting Mr. McMahon's credit card number out there.
Well, again, I'm not saying that I'm saying certainly the last 4 digits. We're not talking about the entire credit card number, but just something that's identifying. I'm not saying you even need even the last 4 digits, but if you have, I need, documentation that indicates that McMahon paid for it, or McMahon paid for it in cash, McMahon paid for it in check, McMahon paid for it in a credit card, right?
McMahon paid for it in a credit card. That was, as I understand it, the only vehicle for payment that was made. And at the beginning, he said, "You got my credit card number, bill them all for my credit card," and that's what happened until it was done.
Okay, and
Your Honor, I apologize, I didn't mean to cut you off. But we'd be happy to accept redactions to the extent that there is identifying information that we can at least tie to Mr. McMahon, if that is what the case is. So whether it's redacting everything except the last 4, we'd be more than happy to agree to that.
Well, you're going to have to be more than happy to agree with that, because that's what I would do. But here's the thing: it's like, you have to find out what we're dealing with. I mean, what's there? Is it, and how is it indicated? Is it indicated by a credit card number? Is it indicated by name? So, and that's why I'm saying that you need to find that out, and then you need to have a discussion about how you're going to turn over those documents in terms of identifying information. And again, if you have to come back to the court, what I would say is that I think it's appropriate to redact everything but the last 4 digits if there's a credit card number that's revealed. Okay.
Yes, Your Honor. I will go back to Dr. Colbert. I cannot tell you exactly what the trail was from how the fact that Ms. Grant received treatment to the receipt of payment by people. I can't give you the step-by-step details of exactly how that transaction took place.
All right, well, let's find out, and then we'll deal with it when we find out. All right. Now, I just want to address the privilege log. Are you asserting, Attorney Silvestri, a privilege in terms of protecting documents?
If I recall correctly, and Ms. Nolan will correct me if I'm wrong, I'm sure, where this was stated in our responses, there were some questions about payments. Well, let me find it. dig out where it is in this heap, Your Honor.
Sure.
I believe it's requests 14, 15, 16, and 18 as to Dr. Kolker, and 13, 14, 15, and 13, 14, 15, and 17 as to Peak Wellness. And the privilege that was invoked was the physician-patient privilege.
I had the wrong document altogether. There were a few objections, references to if documents exist, they would violate Mr. McMahon's physician-patient privilege with respect to the claim about trips to Tijuana.
I'm sorry, with the claim about what?
To Tijuana.
All right. Well, I mean, all is on my concern is that if you're going to make a privilege, if you're going to invoke the physician-patient privilege, that you provide a log of what documents you're withholding based on that privilege. Yes. Did you freeze?
Oh, might be frozen.
All right.
Just the first request production documents to Dr. Kolker.
I'm sorry, Attorney Sylvester, you froze up there for a moment.
Sorry, Your Honor. This is the Dr. Kolker discovery requests. Exhibit, not an exhibit, it's docket entry 136. I believe. And it's Dr. Kolker's responses. Question was any and all documents and communications, including but not limiting to travel receipts, lodging receipts, or expense reimbursements relating to flights taken by you or any Peak Wellness employee or Vincent McMahon to or from Tijuana, Mexico, from March 1, 2019 through May 1, 2022. And we asserted our general objection rather than repeating it again. And saying it would infringe on Mr. McMahon's physician-patient privilege. Now, I don't know how I give a privilege log without disclosing privileged information. If there's a document that exists, and I'm not sure that there is, I'm not aware of any. We go back and look.
Well, I mean, I'm sorry.
So this is pretty remote. I can tell you a little bit of background, hopefully without revealing any information about care that Mr. McMahon was receiving. But providing medical care to U.S. residents is a big business in Tijuana. That's one thing that's kind of a generally known fact. Another thing that I can probably tell you is that, because Ms. Grant may know this, is that if one flies someplace with Mr. McMahon, one does not fly commercially.
Okay. Well, I'm a bit confused here, because the request is, or you're making a physician-patient privilege. You're invoking the privilege, right? On certain documents. Do those documents have to do with specific treatment?
it's my understanding, and go back, talk to Dr. Volker again, that there could be some indication of that. But I can't give Your Honor a definitive answer on whether actual treatment was provided. I do think I can tell you that it's common. It's not unusual for some of the treatments that are available in Tijuana for the patient to have to stay some period of time after the treatment, unless they're accompanied on the way home by a qualified medical personnel.
I still don't know what we're talking about here, because did Dr. Kolker, the request is for records of the treatment provided by Dr. Kolker. Is that correct, Attorney Nolan?
No, Your Honor. We're talking about documents relating to travel receipts, lodging, reimbursements regarding these trips, not as to any medical treatment. Frankly, I don't want to know what Dr. Kolker, what medical treatments were provided. We don't want to infringe on the privilege at all. However, if there is a claim of privilege, it's our position it needs to be logged. Otherwise, how can we assess whether it's responsive?
Well, I have to agree with that. I mean, how am I to know how am I to make a ruling on these documents if I don't know what they are?
And frankly, Your Honor, if I may, I believe it's counsel's obligation to actually review those documents and make those determinations. And I've heard several times today, I think this is what it is, or I'm not sure if there are any documents. And that kind of leads into our larger point that the defendants didn't search for anything.
Well, Dr. Kolker certainly searched for everything. If the request is strictly limited to travel receipts, lodging receipts, and expense reimbursements, period, I anticipate, although I can't say definitively, that the answer to that is none.
I'm sorry, what? I still didn't hear you. I'm sorry, you're breaking up.
None.
There are none.
Nothing. That would be my understanding. I cannot make that representation to you definitively, Your Honor, but that's what I would anticipate.
All right. Well, listen, here's in terms of the issue on a privilege log, if you're invoking any sort of, doctor-patient privilege, I'm going to order that you provide a privilege log for any documents that you're withholding based on a doctor-patient privilege. All right?
And may I ask sort of a hypothetical on that, Your Honor?
You may.
If there's a responsive document, there may not be because of the fact that it's limited to certain receipts. But if there were a responsive document that identified a payment to a physician or healthcare facility in Tijuana, that by disclosing the name would reveal a certain type of treatment, a cancer doctor. I have no idea. I just made that up. I have no idea if that's what it said. I would think that reveals the nature of the treatment that Mr. McMahon was receiving and shouldn't be disclosed. And I would like at least to have an opportunity to review that and raise an objection to something like that if it exists.
Well, Yeah, I would certainly entertain, an objection to something that is maybe specifically revealing a medical condition of Mr. McMahon. The problem is that you have been just deciding, sort of issuing general objections and deciding what you want to disclose and what you don't want to disclose based on your own decision making. And what I want is, any general objection, you have is going to be overruled. If you have specific objections about documents, then you bring those objections to the court. You just don't withhold a document because you find it objectionable.
Well, if I may, Your Honor, I tried to draft that in a way that really wasn't as broad and undefined as you just defined it.
Well, I think the way I'm reading things, and I could be wrong because I'm certainly not involved in the day-to-day discussions that you all are having, but there's certainly a communication breakdown. And, in terms of if a document's requested and I've ordered a document be produced, and at least I believe this is what Attorney Nolan had indicated in her memo, is that we're trying to have discussions about that, and my requests to have discussions are not being reciprocated. So you can't even get to a point where the court can get involved and say, hey, what is this specific document that you're arguing about, so the court can issue an order about it, because you're not discussing what those documents are. So what I'm saying today is that I'm trying to get you to a place to say that these documents I've ordered are to be turned over, okay? So that you go through these documents and you decide if this is something that you want to assert a privilege on that can't be turned over, and even turned over or at least indicated in a privilege log. And you address that, you indicate that to Attorney Nolan in a discussion, and then you address that with the court. Okay, is that that understood?
I wanted to state that to clarify that general objection didn't just say we waved our hands and we're not producing it. It's those requests that are identified in their 18 or so requests that are beyond the scope of the potential alleged claims that they allege that they're seeking evidence for. So but
the court made an order to turn those over. So that's what I'm saying. It's like, if you have an objection to a document that the court ordered you to turn over, bring that specific objection to the court.
Well,
that specific objection.
We thought we were doing that the way we set it up, just to avoid having to repeat the half page of objection each time it came up. But I understand what Your Honor is saying, and we will work on that.
All right. Attorney Nolan, what else is to be addressed that I haven't addressed? What I'll say right now is at this point, I'm not compelling sort of Dr. Kolker to a deposition or to required to answer questions at this point.
I understand.
I'm hoping that we can that today's hearing is going to produce more documents that we can avoid that. I'm not saying that that's not something that potentially could happen in the future if this continues, but I'm not doing that at this point. So,
sure.
Is it
I understand, Your Honor.
What have I missed?
I think the
hold on one second, Attorney Nolan. I'm sorry. Go ahead, Attorney Silvestri.
One more sort of question about physician-patient privilege, there was one other request for security footage, many Peak Wellness premise or property featuring Ms. Grant or Mr. McMahon. And we said, as pertains to Mr. McMahon, it infringes on the physician-patient privilege, but in any event, no such documents exist since the system does not store security footage beyond 3 months. Given that fact, can I inquire if there's anything that Ms. Nolan is pressing on that request?
I'll accept that representation. I would just ask then that the physician-patient privilege, which is invoked, if no documents exist, then that should be withdrawn.
Well, if no documents exist that are more than 3 months old, I'm not sure why you would want to know about security cameras picking up Mr. McMahon within the last quarter of this year.
Through your honor, I don't want to speak directly to Attorney Silvestri without your honor's permission, but candidly, we have very specific date ranges that we've outlined in the discovery request, which I believe will only go through May of 2022. If there are no responsive documents, I will accept that representation. But to that end, the privilege should not be invoked.
If there are, if that's particular request did not have that date range, but if the position is that the same date range as within some of the other requests, which is March, as Ms. Nolan said, March 1, 2019 to May 1, 2022, if that applies to this request that I mentioned, then the answer is there's nothing.
All right. If there's nothing, there's nothing. So I'm not, you can't produce something that you don't have. So or that doesn't exist. So, but I agree with Attorney Nolan in the sense that, you know, if it doesn't exist, then you don't invoke doctor-client privilege on something that doesn't exist in the first place. All right. Did you want to respond, Attorney Silvestri, or?
No, I appreciate that, Your Honor. Thank you.
All right. All right. Attorney Nolan, you were indicating what I missed.
Sure, Your Honor. We had also asked that the defendants comply with the requirements of the practice book to state whether responsive documents have been withheld pursuant to their objections. Again, this was the, under the guise of the rules of the practice book don't apply, was what I was told on countless occasions. So we would ask Your Honor to order that defendants comply with the requirements of the practice book, as well as conduct a reasonable search for responsive documents as they are required.
It's not just complying with the practice book, it's complying with the court's order. So the court's order would, if there are documents that you're withholding, you need to identify what documents you're withholding and the reason why you're identifying those documents. And complying with the court order does also require you to do a search of the documents that I've ordered to be turned over.
If Your Honor, please, after our last session, I did go back with the Dr. Colker and confirmed that he did a detailed search on all of the documents that were requested. And so whatever he did or didn't come up with is reflected in the production. So that's, I think, not an issue. There will, in fact, Dr. Colker did do a detailed search. And he's really the principal custodian of these records. This is not a big company. That he's the medical director and one of only 2 physicians employed at Peak Wellness, which has 1 office. I mean, Dr. Colker searching the records is sufficient. There aren't 15 custodians who have to, like if it was IBM or something.
If
No,
I might.
well, I understand that. Go ahead.
Your Honor, my concern is that when we asked questions at our singular meet and confer conference as to, okay, Dr. Kolker searched for documents. What did he search? Where did he search? What email addresses? You know, anything like that. Attorney Silvestri was unable to tell me anything about that. So I am concerned as to the fulsomeness of those searches if the defendants are unable or unwilling to provide us with the details of what those searches entailed.
All right. Well, I'm going to. I understand that, and so Attorney Silvestri, what I'm going to do is I'm going to order that there be identify if he's the custodian of the records, right? You identify what searches he conducted, which search methods he conducted to identify documents. Again, if he's the custodian of the records, he should have the information readily available as to what types of searches that he undertook. And as to, again, if you're gonna withhold any documents, you know, you need to provide a basis for why you're withholding those documents. Withholding, okay?
Yes, Your Honor.
All right. I think that covers everything at this point, right?
I believe so, Your Honor.
All right. And I'll try to have a written order sort of documenting this out as soon as I can, okay?
It would be extremely helpful, Your Honor.
Yeah, absolutely. All right. Attorney Nolan, did you want to speak on your motion for extension of time?
Briefly, Your Honor, we filed the motion only out of an abundance of caution because Your Honor had set forth specific deadlines in your original order. And it was the week leading up to one of those deadlines. And that's when defendants refused to engage any further with meet and confer efforts. So out of a, you know, as a protective measure, we asked for an extension of time to continue those efforts. Come to find out those efforts were going to stall. So we just asked that any order include some provisions to add on to, you know, to essentially extend those deadlines past whatever deadlines Your Honor sets in this, you know, in this new order. That way we can preserve those, you know, the ability to serve supplemental requests and bring adjudications to the court as Your Honor set forth in the original order.
Give me 1 second, okay?
Sure.
Well, listen, Attorney Silvestri, I'm going to give you some time. You know, I don't want to. I'm going to give you some time to handle this. So I will then, you know, provide, you know, updated deadlines on that when I expect the compliance and. Do you want a specific order in there as to a date for supplemental discovery, or?
Your Honor, I think we'd be perfectly content with if you said 30 days after, you know, the deadline to comply, or, you know, whatever Your Honor thinks is appropriate in line with the original order.
Okay.
rather than a date certain.
All right. And Attorney Silvestri, I'll ask this in terms of a time frame. I certainly understand, you know, holidays are coming up and things like that, but I'd like to get a sort of a realistic time frame. I know.
Well, depending on when we get whatever Ms. Nolan's going to give us, I would think an additional, with the holidays coming up, as Your Honor said, I think an additional 30 days would be appropriate.
Yeah. Well, I was thinking 30 days, Attorney Nolan. I think that is appropriate. So, all right.
We're fine with 30 days, Your Honor. I just want to clarify, Attorney Silvestri seemed to indicate that I was going to be getting him something.
Yeah.
And I'm not sure what that would be.
All right. You had, I thought, if I can address Ms. Nolan directly, Your Honor.
Yeah.
I thought there was something additional that you wanted to put in to clarify something, and that you were going to get us. I'm wrong about that. I'm delighted.
I think basically what it is that that there be discussions if there's compliance and there's issues or questions regarding compliance, or if there's non-compliance and there's an issue, that there be some communication and some discussion. As I said, good faith. I said good faith this morning, and sometimes I don't even know what that means, but a good faith discussion as to sort of resolving those problems, if at all possible, before you came to the court. Okay.
Yes, Your Honor.
All right. Is there anything else we need to do to discuss?
Just so I can accurately report back to my client, Your Honor will be issuing new orders, and our time to respond to anything new that we have to provide would be, did I get it right, would be 30 days after we see your order?
Right. I'm going to try. I'm going to get it out. I'll get an order out this week. Okay. And then what I'll do is I'll calculate a 30-day date right out from there. So a specific date that's, 30 days or.
Yeah. If I could request that the 30 days not count the last 3 days in Christmas week.
Well, what I'll do is I'll accordingly stretch it out to about 35 days, or
I think that would, thank you,
so that everybody can enjoy the holidays however you like to enjoy the holidays. All right.
Appreciate that, Your Honor. Thank you.
Oh, absolutely. Is there anything at all that we need to discuss further? No.
Nothing further from us, Your Honor.
All right.
I hope not, Your Honor.
All right. Sounds good. Well, thank you both. Thank you all. I appreciate it. And like I said, I'll have an order out as soon as I possibly can. And other than that, I will wish you wonderful holidays. Okay.
You as well, Your Honor. Thank you so much.
All right. My pleasure. You all take care now.
All right. Bye-bye.
Thank you.